Thank you for joining us for our video about conflicts of interests on not-for-profit boards. My name is Jody Adler, and I am the Director of the Community Law Project and Pro Bono Relations at the Chicago Lawyers Committee for Civil Rights. The Community Law Project provides free legal assistance to Chicago-based economic development and social service nonprofits and eligible entrepreneurs for their business legal needs. The following video is part of a series we developed for persons serving on nonprofit boards to understand the role of the directors. The videos cover board responsibilities, fiduciary duties, directors and officer responsibilities, conflicts of interest, the relationship between the board and the executive director, and recruitment of directors and their orientation. If you have questions about the content of this video or need pro bono legal assistance, please email us at clp@clccrul.org or visit our website listed at the end of this section. This video is on conflicts of interest. So what are conflicts of interest? A conflict occurs when a director or an insider has a personal or professional interest in an action being contemplated by the organization. And that person has a voice in determining the action, but doesn't disclose their dual interest. Conflicts often occur when there's also a violation of the duty of loyalty. If you've watched our fiduciary duty video, you'll remember that the duty of loyalty requires directors to always put the interests of the organization above their own. A conflict occurs when the director does not do that, when the director has a personal or professional interest in seeing the organization take an action because they may financially benefit from that action and should have the interest of the organization ahead of his or her own and make sure that the organization's action actually benefits the organization and not the individual. The thing to keep in mind about conflicts is that they are not inherently bad, illegal, or unlawful, but they have to be managed appropriately, and we're going to talk about that as we go through this example. So, let's assume that the organization is considering entering into a contract to purchase land, and that Director A owns land and through a corporation. The organization looks for bids to consider buying two different parcels, one of which again is owned by that director. If the director does not disclose that they have an ownership interest in that property and participates in the decision making of the organization, then that director has a conflict of interest. Conflicts most often occur when the organization is entering into a contract or determining compensation for an individual or a business that somebody has an interest in that has not been disclosed. But there are other possibilities of conflicts that may arise in less common areas, such as when you have an individual serving on your board who serves on two boards or another board that has a similar purpose to your organization, and the organization is making a decision about funding, and that director doesn't disclose his other interest. Or if a relative of an ED holds a salaried position at the organization, and there's decisions being made about salaries and the ED is involved in those decisions. Even when there's a board member who is a parent of a client or a beneficiary of the organization, a conflict might arise when the board is making determinations about services that are being provided. That parent may have a conflict. So it's important to keep in mind that when the conflict arises, that it is arising because there is somebody on the board who has dual interest in making a decision that the organization is undertaking. How do you avoid a conflict of interest? The way to avoid violations is to have a conflict of interest policy, but not just have a policy. Have a policy that's reviewed and signed annually and discussed at least one board meeting. Additionally, the conflict of interest should have a disclosure requirement so that directors are upfront disclosing areas where they may have a conflict with the operations of the organization. And that should also be updated on an annual basis. The IRS has determined that there is a rebuttable presumption when a conflict arises if certain steps are taken by the board to address those conflicts. You also want to make sure that it becomes kind of routine at board meetings for board members to disclose their potential conflicts. It should become customary for a board member to say, I have started a business that's going to potentially enter into a contract with the organization, or I serve on another board and the other board is considering these same issues. It also might be a value when the board president feels comfortable saying the next agenda item relates to joining a collaboration with other organizations. I'm going to ask the board members now if any of you serve on any of these other organizations to help identify whether there's a potential conflict. And you want to make that routine so it becomes something that is normally happening at the organization. So as I said before, the IRS has determined that if there are certain actions taken, there's a rebuttable presumption that the conflict has been properly addressed. And how do you do that? How do you create the rebuttable presumption? Basically what it means is that the individual who has the conflict has to disclose the fact that they have the conflict. The organization then needs to obtain independent information about the bids or the compensation or the contract that it is thinking of entering into to make sure that the contract is in the best interest of the organization. The way this comes up is, again, in the land situation. If the organization is looking at buying a piece of land and I happen to own that land, I need to disclose that I own the land and offer the land to the organization for a certain price point. And then the organization needs to get independent verification, whether it's an appraisal, whether it's two other realtors who give them an idea of what the value of that land is. When the board discusses this, the director who has that interest should not be present, and when they vote on it, the director should not be present. So the director should recuse themselves from the discussion and the vote, and then the minutes of the board meeting should reflect that the potential conflict was disclosed, that independent verification of the price was received, that the director with the conflict left the meeting for the discussion and the vote, and that a decision was made. What you're looking to do is make sure that the decision is always being made independently of the individual with the conflict, and that it is in the best interest of the organization because it's either at fair market value, below fair market value, or it's the best opportunity for the organization to move forward. If those things happen and the organization decides to enter into the contract with the director that has the conflict, then what the IRS comes back and it says is that that is a rebuttable presumption that it's been addressed appropriately and that the director is not taking advantage of his or her position on the board. So what are the consequences of a violation of a conflict of interest? It's a little bit different if you are operating in a 501c3 organization or a 501c6 organization. The 501c3 tax-exempt organizations, the IRS can impose something called excess benefits on the party who has received the benefit of that conflict. And that is an excise tax, and the individual has to repay the amount of the benefit and pay the excise tax. If it's not paid back within a certain period of time, that excise tax is increased. That's one option. It's called an intermediate sanction. The IRS can, if it's egregious enough, also just take away the tax exemption of the organization. But frequently there is this intermediate sanction determined, which is an excise benefit first. In a 501c6 organization, excess benefits and intermediate sanctions don't apply, but the IRS can still come back and revoke the tax exemption of the organization. So the consequences are very harsh. The ability to address the issue through rebuttable presumption is very easy, so we always recommend that organizations have a conflict of interest policy that explains what the rebuttable presumption is and that they follow that process. There's also a possibility that the Illinois Attorney General, who has the direction of all the organizations in the state of Illinois that are soliciting funds for its purposes, to protect the interests of the state, the residents in the state of Illinois. So there's a possibility that the Illinois Attorney General would also come after an organization that had violated the conflict of interest in this way. So what's the most important thing to remember? The most important thing to remember is that you want to have a conflict of interest policy that is looked at annually and signed off on by each director annually, that there's a disclosure form and the directors can disclose on that form annually where their conflicts potentially will be and what organizations and businesses they have common interests in, that you create the rebuttable presumption and you create a culture of disclosure where it's comfortable for a director to disclose that they may have a conflict. Thank you. If you have any questions about the content of this video or need pro bono legal assistance, please email us at clccrul.org or visit our website, which is listed on the slide.